Hello. So I'm going to start with the webinar of today. What are my landlord's obligations? But first, just remember and housekeeping things. So I remember I'm Jael Duarte. I'm the Tenants Advocate for the Coalition for Tenants Rights. You can see on the slide my email, my phone number. One of the duties of my role, it's this pedagogic education, but also I'm able to guide tenants in navigating the system. And you're going to see maybe I need to help you with that. If you are seeing what we're going to see in the webinar today, this is not a governmental or state position. This is a position made by the Coalition for Tenant Rights, which is a collective of activists. Just to be clear about that, I'm speaking from the unceded and unceded territory of Wollastic, Mi'kmaq, and Passamaquoddy. I'm a lawyer. I'm governed also by the Law Society of New Brunswick. And according to that, I'm not able to answer particular question for a case in public. So if you have a questions, I'm asking you to make it general. Even if it's your case, you make it general, because I'm not, for confidentiality, I can't answer in public particular question for particular cases. So thank you for attending, and I hope this is useful. For people who can't attend today live, this presentation record, and it will be available in a few weeks at the Facebook page of the coalition. So we start about landlord's obligations. So for this part in particular, I thought it will be good to point it out in which sections of the law you can find when I'm telling you. So if you need it, you can find it by yourself. So I'm basically talking about the Section 3 obligation, landlord's obligation, and the Residential Tenancies Act. So Section 3, 1, so the landlord shall deliver the premises to the tenant in a good state. So it's something that could be obvious, but sometimes it's not. Clean and repair and fit for habitation. So the premises, the apartment, the house have to be habitable. So the landlord have to maintain also in a good state. So if something is not working at the apartment, at the house, it's a landlord obligation. So you have to tell the landlord, I don't know, the pipe is not working, you have to hire a plumber. The electricity, something is happening here, so please address first the landlord. That is a landlord obligation. So the shall to deliver the tenant and maintain in good state. So deliver and maintain. Chattels. What means chattels? Chattels is all the things that comes with the apartment. Many times, and that is really usual in Canada and in New Brunswick too, the apartment is rented with the oven, or with the fridge, or even a microwave, the washing machine, the dryer machine. So that is called chattels, for example. And if the apartment, the house is rented with that, it is an obligation of the landlord maintaining good state that this kind of chattels, things that comes with the apartment. So if that breaks, you can address the landlord and say, hey, the microwave broke. Is broken. So that is really important. The landlord shall comply with all health, safety, housing, and building standards. So there are basic things that everyone knows, that, for example, having a fire exit also. It has to be an entry, it has to be a fire exit, and that is part of the safety standard, health standards. With COVID, we at the coalition have been discussing, and I also was consulted about, for example, what happens when the landlord wants to show an apartment and the person and the tenant don't feel safe because COVID. For example, if a tenant, that was easier to distinguish when the measures for COVID and the province were clear. Now that we know COVID is in the air, but the measures from the province are not clear about how to prevent the spread of COVID, for example, I think and I believe if a tenant it's for example vulnerable and don't feel safe with showing apartments in a way, and there is not another way, because there are ways to show an apartment. There are online showing or making safe, the person is not there, cleaning. So that is health, that is safety. And I believe the tenant have to raise that point. If someone have questions, you can write the question to the chat. There is a person in the chat with the label questions, and please write the question and I'm gonna answer at the end. But thank you for your question. Don't lose it. Please write it and I'm gonna answer. The landlord have to keep all common areas in a clean and safe condition. There are basic things. If a corridor is being cleaned, that is putting a sign, the corridor is wet, for example. That is safe conditions, and I'm thinking mostly about elder, for example. That is an accident when you are an elder is not at all. It's not an accident is never fun, but have more consequence when the health of the person, of the age of the person, don't allow a fast recovery. So landlord's obligations. So these sections apply. So cleanliness, repair, fit for habitation applies even if when a tenant entered to the apartment of the house and it wasn't complied. So it's not an excuse that the landlord said, but when you entered to this apartment, that was the state. That is not an excuse. Even in that situation, the landlord have to keep clean, have to keep fit for habitation, and have to repair. Prohibition of the landlord. So a landlord of his agent or representative. So we mean the person who owns the building, but also the agent, the real estate agent of the company, or the representative, the secretary of the company, the person in charge, shall not never interfere with the supply of heat, water, electricity, never, except for an emergency, of course, and have to be being able to repair and to maintain. The landlord can't never to rent a premises, so that the apartment, the house, unfit for habitation. It can't deliberately. I'm gonna do that because I want this tenant go away. So I'm gonna cut the power, I'm gonna cut the water, I'm gonna cut the heat. That is that is really clear in the law. It's a prohibition for the landlord. What happens if a landlord failed to comply the obligations? So, and I really want to do an emphasis here. If it's an emergency, you inform the tribunal. So you call the tribunal, you address the tribunal by email, by fax, by a letter. But if it's not an emergency, you have to do a notice for the landlord, and that is, the law is clear about it. So I encourage you, if you are in a situation like that, please write a notice. So it has to be in written, with the address, a date, and signed by the tenant. That is the requirements for the notice from the tenant to the landlord. And that is really important, and we're gonna see in the next slides why. So what happens with the notice? So you write the notice, the landlord doesn't answer, don't answer. So you go to the tribunal. The tribunal may conduct an investigation. They are gonna try normally to mediate first and to tell the landlord, hey, please comply your obligations. But they may conduct an investigation. They may inspect the premises and after require the landlord to comply the obligations. The tribunal also may perform the obligation of the landlord. That is really, really interesting in the law. So the tribunal, the tribunal can say, okay, so it's not repair, I'm gonna repair. And we're gonna see the consequences of that in the next slide. But look, if the tribunal can do that, can comply the obligation for the landlord, have to, after it was a notice, so the tenant had to do a notice, it was an investigation conducted, and the landlord cannot be reached by the tribunal to advise him if there is an obligation of the emergency. So it's really, really important, the notice. Please be aware, you have to do a notice written with the address where you live and the signature and the date. That is really important. Without that, the tribunal is not gonna start their process. And unfortunately, and I take advantage to remember, unfortunately, the law see tenants and landlords as equals. So there is no obligation for the tribunal to guide the tenant. They can do it if they would like to, but they are not obligations to do so. However, and I also encourage, if you are an elder, a person over 65, or there are children involved, or there is a person with a disability, I encourage also, if you are in a situation like that, to reach out also the child advocate, the senior advocate. Why? Because that is their duty. They can guide you, help you to do the notice and to advocate for you during the investigation. So the officer also performs the obligation of the landlord, and the landlord is liable for the cost plus interest. The officer, and where is the money? Why the government will do that? So the officer may, before or after, require a tenant to make the rental payments to the tribunal and advise the landlord by notice. So that is the money coming from. So what could happen is the officer, so you do the notice. You don't have any answer there, positive answer, well, fixing the problem, because it's not only an answer is just, yes, I'm gonna do it, and they take long and long and long. No, I do it. If you don't have a really effective answer from the landlord, so you go to the tribunal and say, hey, my landlord is not complying their obligation, and this is the notice I made it, and they are not still complying. So you go to the tribunal start an investigation, do an inspection, maybe, and or decide, and after they decided to fix, and they say, you tenant, you stop paying to the landlord, you pay to me. So you pay to the tribunal, and from that money, the tribunal do comply the obligation, fix what it has to be fixed. And after they require that money from the landlord. A tenant after the notice may apply to the tribunal to terminate the tenancy. So remember, I said, please do the proper notice. It's really important doing a proper notice. The proper notice is written with the address, with the date, and your signature as a tenant. And after the notice, you advise the tribunal, and you say, you know what? I can't live anymore like that. And that is a possibility, a legal possibility to terminate your contract. So you fill the form provided by the tribunal is gonna give you the form, and you serve a copy of that form to the landlord. And you decide when you are terminating the contract. So you said, okay, I found it a place and I'm gonna leave tomorrow. I'm gonna leave in a week. I'm gonna leave in a month. But but I can't continue living like that. So you terminate the lease, and you, in the day you specified in the notice. After this notice of termination, the landlord may order to pay a sum for the tenant. And this is another important thing. So the tribunal can order to the landlord to pay a compensation for any reasonable expenses, not exceeding the rent payable. So no more than the months you are the month you are paying, but the tribunal is going to ask you for proof, for evidence. So if you are inquiring cost for this termination of the contract, so please keep the receipt. Please keep the receipt so you can ask, because it want to be, and I believe it's going to be that always talking with the tribunal, they say, what is the evidence? So keep the evidence of the cost you are implying. And unfortunately, and I say unfortunately because in some cases, it will be maybe the expenses more than a month of the rent, but the law says no more than a month. So you can be also reimbursement for rent if you had to go and you had to pay another one, and so not exceeding an amount also that you paid by the tenant if the premises were uninhabitable. So if you couldn't habit, if you couldn't live in that apartment, and be careful about that, it says if the opinion of the residential tenancy officer, if you can't live, so you have to prove. So that is, again, I'm encouraging. So two things, notice and evidence. So take pictures of things. Ask a friend to do a declaration. If it's a declaration with a notary, it will be better. Make evidence, and evidence record noises. For example, it's a question of noise. Make evidence so you can show. Oh, what happened here? Sorry. Okay. Now I'm lost where I was. Well, whatever. So you have to do the notice and look for evidence. Yes, I was here. Yeah, to convince and to take the opinion of the residential tenancy officer that nobody can live in that conditions. Otherwise, maybe the opinion of the officer could be the opinion of the landlord if you don't have enough proof. Because the landlord will show their proof too. And that is the sad part, that the landlord is gonna defend, and they're gonna show their proof. Lease terminated by the tenant. So if the lease is terminated by the tenant, the landlord is not entitled to compensation. So the tenant can't end because the reason proof that nobody could live there. Not entitled to compensation. The damages in relation to rent, it's so the tenant doesn't have to pay it, and there is no other action of proceedings against the tenant. The landlord couldn't go to the court neither, because it's proven that the tenant ended the lease because the conditions and because the landlord wasn't complying their obligations. So as you see, it's really a question of proof, and you will be good if the tribunal say yes, it's a contract terminated because the landlord is not complying the conditions. So once that happens, there is a notice to quit of the tenant. So the tribunal will say, but this is the last one, and I'm gonna attract the attention because it's really, I find we are talking about the obligation of the landlord, but this article and this section 6(8) give the possibility to the landlord to apply to the tribunal for on a notice to quit for the tenants if there are destruction of the premises. So the landlord can also terminate the contract if they don't comply the obligation, and that is weird. So reading this, I truly encourage you to do the first, to do the notice, to do the complaint to the tribunal. The residential tenancy officer determine what is reasonable. So if you went first and you show enough proof, you have more possibilities that the officer is gonna decide on your favor. Even there, if you have a notice to quit because the destruction of the apartment of the house from the landlord, and you are able to demonstrate that it is not too bad, well, maybe you don't have to quit. So it's a question of proof. And that is why it's important, if you see something you don't believe in the well behavior of the landlord. And unfortunately, that is how the law is made, that if the tenant don't complain, don't do the proper notice, and don't go to the tribunal, after, it's going to be more difficult for the tenant. So this is my presentation for today. Now I'm ready for some questions. I remember it was someone raising her hand.
So if anyone has a question, you can send it to me. You can see my name says questions on it, and you can send it right in the chat. I'm not seeing any just yet, though.
Okay.
Okay, we have a question. It says, who is responsible for initiating fire department inspections?
Well, I think that is a question of safety. So anyone, if there are children involved, for example, anyone could do it. And I know that is a big question because I have been accompanying some tenants being, well, it's not technically evicted, but asking to leave the apartment because of fire department inspection. So the situation is this, and I'm gonna be more clear about it. Let's say you as a tenant think it's important to do a fire department inspection. What I suggest, and why? Because the exit for fire is not well fitted. It's an stairs that is really, if someone uses it, it's gonna break it down, and it's more dangerous than staying in the fire in a way. So if you see that in that apartment, I strongly suggest to write a notice to the landlord first. And if you see it, and I will say, you never know when it's a fire. So I will say that it's an emergency. So you go to the tribunal directly. You say, and I will say, you do but just in case you wash your hands. I did what I have to do. But and it's gonna be the tribunal is gonna be, that's gonna start the process. And you will have more in your hands as a tenant the situation that just waiting for a notice to quit from the landlord because the apartment of the house is not safe.
All right, there's another question. It says, hi, Jael, have you experienced situations that defined what constitutes an emergency under Section 6, 2.1?
Yes, yes, I have been seeing that. For example, when there are rodents, rats, and there are children, that is urgent. That is something that it could be, and many situations are urgent. Yeah, if you have children and even and there are things like that, and I will say that it's urgent. It's urgent when there is you make the notice, or you see and you call, you saw a cable which is not working well, and you are seeing, oh, I don't want to sleep this night here, and you call the landlord and the landlord is not responding. So I will say you go to the tribunal. Please don't be afraid going to the tribunal, doing this notice. I know and I understand it will be a difficult step, but it will be more difficult if something happens. And even there, the tribunal is going to blame the tenant because the tenant didn't say so. Well, Sarah, I saw a question was directed to me directly, but I'm going to answer because it's asking about evictions and warnings of 3 written warnings for evictions. This is part of another webinar. The eviction is not too complicated, but that requires a whole webinar. So I just want to tell the person who asked it that I saw her message, but I'm not going to answer the question today because it's a webinar. Let me see. It will be on July, at the end of July. Another question, Sarah?
I don't see any right now, but if anyone has one, they can send it to me in the chat.
Yeah. Okay.
Oh, I see another one here. It says, what do you think needs to change in the Act to better protect residents?
Well, there are many things to change in the Act. Regarding the obligation of landlords, which is the subject for today, I really think that that part has to recognize the imbalance of power between landlords and tenants, and have to make it easier for tenants to require the protection from the tribunal. So when a tenant is seen as vulnerable and there is seen an imbalance of power, so it's really important that the Act is going to see, but here the Act is not going to shine. Even is given the possibility for the landlord to terminate the contract when they don't comply their obligations, and that I say I for started that section I think it will be banned if I was the one writing the law, and also you have to be clear more consequences for landlords who don't comply their obligations more than that limit that is established of a 1 month rent.
Yeah, so I'm still not seeing any more questions, so I'll give people a few more minutes maybe. If anyone wants to ask a question, now would be the last chance. All right, I think we can wrap it up, Jael.
Yes, I think so. So there is my email, there is my phone number. If you have a particular question about a case. And thank you for attending. Thank you for being there and listening. Next, April 12th, it will be the same subject, but in French. So, and the next subject, it will be the tenant's obligation in English and in French. Well, have a good day. Goodbye.